Hi, good morning. Today is October 25, 2025, and it's 9:44 a.m. US Central Time. And I'm recording this video from my home at the 26714 Valleyside Drive, Katy, Texas, 77494. I'm just recording this quick, so this would be like the fourth part of the series of videos that I recorded yesterday. So this is just a small addendum. It's not really a full video. It's just to record an observation that the legal vaccine flag that could be important. I don't know, right? So I'm just going to say observation in case any authorities, anybody from the authorities see this video, in case it helps, right? But it seems, from what I'm saying, it seems to me like kind of a logical legal deduction, right? Legal concept. And I imagine, a prosecutor wouldn't need me saying this, right? Like they would probably know this. But I'm just going to say about the pipeline flag, okay? So let me share my screen with you. And I'm going to share the docket, right? The infamous docket of 25 DCV 328122, right? So the observation is the following, right? And to get context on what I'm going to say, I recommend you watch the previous three parts of the session yesterday, right? Because so I don't repeat. I'm not going to repeat here all the observations because there are a lot of observations, right, of different irregularities in this docket that hint and probably show, right? Not hint, but like show that this docket was doctored, was altered was tampered with, right? To try to hide, right, the procedural abuses and the fraud upon the court, the multiple frauds upon the court. So, but what the but to give the short story, the working theory is the following: that probably Morgan Hagner submitted that document that she called temporary restraining order. Yes, let me increase this a little bit. Yes. So this document that she called, sorry, let me do this way. Okay. This document that she called temporary restraining order, setting an order setting hearing for temporary order on index 5, right? And for some reason, my mouse, I think it's not showing. Let me see. Okay. So this one over here, right? Temporary restraining order and order setting hearing for temporary orders, which is index 5. Okay. Um, so and I showed that document yesterday, right? The document is not really a temporary restraining order. Is an order, a proposed order. It's not even an order, right? It's a proposed order scheduling a hearing, but she mistitled it to create this fraudulent entry, right? To discredit it. And then the sequence is that there's two objections from the court staff, right, about the document, that index number 5, right? And one of the complaints is that the document is missing the signature block, which is false. In fact, let me show you the document, right, to do this properly. 1 second. Okay. Yeah, something is not working here. Okay, now it's working. Okay, so you see the document is really, I don't know if you can see that there. Let me see. The document is really setting a hearing, right? So it says it is ordered that the above matter is set before the court. So it's not really at 9 a.m. on May 15, blah, 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 right? So it's not really an order. And you can see that the service was on 4/9, which matches what the docket says, and you can see that it has indeed the block of for signature, right? So that entry saying that, let me go back to the, let me go back to the actual docket, right? Okay, 1 second. The screen sharing is not working correctly today. I don't know why. Let me see if I can share my entire screen. I don't know. Okay. So here, right, you can see that right. So they're complaining that there is no signature block. I showed you that there is, and they're complaining that there's not an independent temporary restraining order, right? And they're advising the council how to file it correctly. And then this was on the 10th, right? So these two complaints. And then, actually, let me look at something here just to be sure. So let's go back in time to that April, right? So she files on Wednesday 9th. The comments complaining about the document are on Thursday 10th of April. And then the judge signs on the 11th, which is a Friday, okay? And it says TRO. Now, this is interesting. Oh, no, this makes sense. I understand now. Yeah, so this is super interesting. It was a Friday, okay? I think this is a fatal flaw because on Fridays, this particular court holds all the hearings over Zoom. And I know that because the petitioner told me, right? In one occasion, we had a hearing on, I think it was the October 10th hearing, which was a Friday. And I asked her, are you going to the court? Are you going to drive to the court? Can I come with you? And she told me, no, tomorrow is over Zoom. On Fridays, it's over Zoom. She said that. She said that on Fridays, all the hearings are conducted via Zoom video conference. She told me that. And this has another implication, right? It means that she knew that, right? How is that she knew that and I did not know that? And we supposedly both attended to the same hearings, right? This always was in my mind, how she knew that, right? And I think I know how, because the signing of this temporary restraining order on April 11th was a Friday, and she probably attended, I'm guessing here, right? But it would make sense how she knew that on Fridays, the thing is over Zoom and not in person. And I did not know that because I had never been called to a hearing on a Friday. That was the first time. That October, I think it was October 3rd, was the first time. Yes. And because it never happened before that it fell on a Friday, then I didn't know, right? And I think it's because on Fridays, I'm imagining, right? On Fridays that they sign the orders, right? That they work on through the week. So she knew that because she went to that hearing, right? This is a hypothesis. I wasn't there, but I imagine that that's what happened. So this kind of reinforces the theory that there is a temporary restraining order inside, right? That Morgan Heidner has, which is document index 7 that disappeared from the docket, and only she knows what it contains, right? But if this is the case, this is a fatal flaw, because if it was conducted over Zoom, that must be recorded and must be accessible to the FBI. So the FBI could easily see, I'm imagining, right, what was said in that hearing, right? Although nobody was aware of what was going on, but this must be recorded on Zoom servers, right? And to get you closer to the goal, we can see the meeting ID. We can look for 387 Judge Telfair Zoom, right? And that will give you the meeting ID. So the meeting ID that people should be looking for is this one from Judge Bell, right? Because he's the one that signed the order. So it should be the meeting ID 475-788-2292. I repeat that it's 475-788-2292. And just for reference, the Judge Telfair meeting ID would be 979-062-9033. And that's important because you can see there the, if authorities investigate this, right, there should be a recording of the October 10th hearing in which I was not able to even object, right, to the procedural abuses. So I think that's probably a fatal flaw on their plan, right? Now, but going back to this, right? So what the pipeline flag is the following, and what I had open is important because let me show you. The judge, so Judge Bell, his first name is Richard, right? So that is consistent with RB, right? So this RB in this docket entry that of the judge that signed that temporary restraining order that is missing from the docket. You see, it goes from index 6 to index 8, right? There's no index 7, which is allegedly the document that Morgan Hagner probably filed, because if it incremented the index, it's because it was filed, right? But somehow it was removed from the docket. But the logic tells you that if there are a series of suggestions from the court staff about the document being flawed, and then immediately it gets signed, and there's an index number missing, the only possible logical explanation I can see is that she corrected the errors and filed a new document, right? We don't know what it contains, but that was what got signed. So, but here is what the pipeline flags, right? So the pipeline flags that to issue a temporary restraining order, and see, there is no hearing. That's the other anomaly, right? So on the 10th, right, which was a Friday, on the 11th, there is no hearing. And if you compare that to October 10, there is no hearing. So they don't put the hearings, right? So this means that the hearings on Friday that are over Zoom do not appear on the docket, right? Unless they make an explicit entry, right? But let me see. This is interesting. So some hearings are scheduled and they do appear in the docket, right, as a schedule, but some other hearings do not appear in the docket, right? So how Morgan Hagner secured that TRO, right? Because I imagine, right, that she cannot do this by submission, right? I mean, this is such an extreme measure, right? Taking a temporary restraining order against the person without them knowing. And I know this because I've been exposed to this legal system for 6 months, and I've tried. For example, when I saw the tires that had the metallic mesh showing, the tires of the black Tesla where the child is being transported, and I saw the risk to the child, the safety risk, immediate safety risk, I filed a temporary restraining order, right? A motion for a temporary restraining order. And I know that the bar to get those is high, at least for me, right? Like when I try to do it, I haven't been able to get a temporary restraining order against the tires, right? For the tire situation, which is an immediate danger to the child, and I have photos of the tires. And the expert saying these tires are going to blow up any minute, right? And with all that evidence, I was not able to secure in any court a temporary restraining order. So what I'm saying is that to secure a temporary restraining order against a person without them knowing, so using an ex parte, hearing, I don't know what it's called exactly, but a hearing where the party that you are seeking the order against is not present, right? That is justifiable in extreme situations, right? Like for example, when if there's allegations of mental issues, right? Like if the person is crazy, it's justifiable that you're not going to drag the person to a courtroom, right? To have a hearing with them. Or if there is an imminent danger of violence, like domestic violence, like physical abuse, things of that nature, right? Like if the person is aggressive and has, threatened the life of the party that is seeking the temporary restraining order, you're not going to drag that aggressor into the court 10 feet away from the person that is being, physically attacked, right? But what's interesting is that, so the thing that the pipeline flag is that there is no hearing before this sequence of events of April 9 to April 11. There is no hearing anywhere in the docket, right? There's no entries of any hearing or anything that happened that would imply that there was a hearing. So that's anomaly number one. The second anomaly is that, as I said, to obtain such an extreme measure, a temporary restraining order against the person, it's the bar high. And beyond that, right, it's not only obtaining it, it's obtaining it without conferring with them or calling them to a hearing, right? Getting them into a hearing. That it's even higher. The bar for that is even higher, right? Because you have to justify that it's a dangerous situation to bring this person into the courtroom, right? So the question is, so the pipeline says, Morgan Heibner must have presented very, very powerful and compelling evidence to Judge RB, which the pipeline now thinks that it's Judge Richard Bell, right? Very, very powerful evidence to Judge Bell to make him sign that order, right? Now, and this is an interesting sequence of it's like a graph, right? It could go in different ways, in different paths, okay? But it's interesting any way you look at it. It's very interesting. So I'll try to explain this in a logical way, but it's a bit hard. So yes, so Morgan Heibner must have presented very, very strong evidence to Judge Bell to justify not only the extreme measure, but also taking that action without the other party even knowing, right? Or being notified that this was taking place. And there is no hearing or docket entry about any hearing in this docket, right? Before that temporary restraining order was signed. But what the pipeline flags that could be a bump is the following, right? If you go down, right? So in that temporary restraining order and order setting hearing for temporary orders, right? That Morgan Heibner submitted, right, on 4/9, and then corrected at some point that we don't know if it was the same. Well, it must have been after the 10th, right, on the 10th or on the 11th, because the comments pushing back were on the 10th, right? So at some point between the 10th and the 11th, at some point in between these two docket entries, she submitted a new document which got the index 7, but then got removed by somebody, and she got logically that signed, right? Now, and got signed by Judge Richard Bell, right? According to the initials RB, and it has to be a judge who signed this, right? So it seems like there's no other judge in this 387 that has those initials. And Judge Richard Bell is the associate judge, I believe it's called, of Judge Telfer. Like they work in pairs, right? Like it seems like, and I don't know if I got this wrong, right? Like I might be wrong here. because again, I'm a pro se litigant and I don't know the implementation details of this system, right? But it seems like Judge Telfer is more senior than Judge Bell. That seems to be the setup. But they work together as a pair, right, in the same courtroom, and they load balance the cases among them. So anyhow, the train of flagging here is that the evidence must have been extreme, right? That's point number one. To be able to get this temporary restraining order without the other party even knowing, right? Secondly, that the other thing that is flagged is that there's no entry for any hearing, there's no record in the docket of any hearing before that temporary restraining order was signed, which is odd, right? Because it's such an extreme measure, especially if it's taking away parental rights, which is probably what happened, right? Because remember, Morgan Heibner secreted the child for 50 days, so she must have been very confident that she could do it. So the evidence must have been very powerful, right? And again, the pipeline gives me like a few possibilities, right? But the one I see more plausible is the mental illness path, because that's what they've been pushing throughout the last 7 months, right? To send me to a psychiatrist, and that, you know, it's for my own good and things like that. So probably that was the argument, right? That they use mental illness, right? But the evidence must have been very powerful to compel the judge to sign that, right? Without even telling me or calling me to a hearing. But this is the interesting thing. In that order, the other thing that the pipeline says is that when those temporary restraining orders ex parte are taken, right, usually they are for a very short period of time and for a very narrow scope. Like, for example, when I use the pipeline to generate the motion for a temporary restraining order about the tires, the request wasn't to strip her from her parental rights because the tires were defective, right? The request was to order her to not drive the child in that car until she provided the court with proof that the 4 tires had been replaced. That was the request, right? Like, very narrow. Like, she can drive it in another car. Like, not even asking that she cannot drive the child, right? She can use another car. She can rent a car. She can borrow a car from a friend, like whatever, right? But in that particular car, the request has to be very narrow, and it has to be in a temporal space limited, right? Like, you cannot make a temporary restraining order that lasts 6 months, right? Without a reasonable justification, right? You know, if it's a person that it's, you know, it's a danger to society, right? It's a serial killer, I imagine, right? That you could get something long term, right? But that's why it's called temporary, right? So anyhow, this on itself, the pipeline thinks that it's a series of presents a series of anomalies as well. First of all, because in that document that Morgan Heibner presented, right, which is, let me show you, right, that she titled Temporary Restraining Order and Order Setting Hearing. So this was on April 9th, right? But she is setting, and this is something that she's proposing, right? May 15th. So she's proposing a date that is almost 6 weeks out, right? And remember, this got flagged because Morgan Heibner, I have emails in the pipeline where it's clear that Morgan Heibner is able to schedule hearings with 2 days notice. So why would Morgan Heibner intentionally, because this was a document produced by Morgan Heibner, it wasn't like the court gave this date. She produced this document, right? And it is demonstrated that she can schedule things in Judge Telfer's calendar with 2 days notice. Like, this has happened multiple times, right? So why would she intentionally, if she's seeking emergency relief, wouldn't be the reasonable thing to do to secure a hearing soon, right? Why schedule it for 6 weeks out, right? Well, the reason is because they didn't know for how long they needed to keep the child, right? Like, if I was going to be coerced quickly or not, right? So they needed buffer. So this shows design, right? The choice of that date. But also, the more important thing is that, as I said, in these cases of temporary restraining orders and that are obtained ex parte, right? They have to be narrow in scope and short in time, right? You cannot secure one of these things for a year, right? To last a year. But then, what the pipeline thinks is powerful is the following, right? Fast forward to May 15, right? That date. And then you see the entry for that hearing, right? So this hearing did have an entry, right? Temporary restraining order hearing, 9 a.m., judicial officer, Oscar III, Telfair Oscar III, right? And you see the docket entry. The docket entry is signed by Judge Bell again, right? So the same judge that potentially signed the mysterious temporary restraining order, index number 7, that only Morgan Heibner knows what it says. And I say that because it's not even in the docket, right? So if a court wanted to see that document, they couldn't because it's not in the docket, right? So and this is interesting, right? Because remember, the judge must have, number one, seen with his own eyes very powerful evidence on April 11th or April 10th or 11th, right? That would merit taking an extreme, narrow, and short-term measure to protect the child, right? That's the only explanation. But yet, on May 15, the very same judge orders, and it says in the docket, Attorney Heibner appear with petitioner, respondent appear pro se. Parties ordered to mediate. It wasn't a suggestion. They were ordered to mediate on or before June 13, 2025, with David Perwin, right? This attorney, former judge, who was appointed to the bench by Governor Greg Abbott years ago, and is now a mediator. Parties may set to hearing if mediation is unsuccessful. And again, it's signed by Judge RB. The contradiction here lies in that if this very same judge, just 5 weeks ago, saw evidence so powerful about potentially, the only reasonable thing to think is that it was about mental illness, right? Because that's what Morgan Heibner has been alleging in the case from day one, right? How can the same judge order this party that is so crazy that cannot be even called to a hearing to defend against a temporary restraining order? How can this judge order this very same person, this very same crazy person, to mediation with the attorney that declared him crazy just 5 weeks ago to secure a temporary restraining order? So in my first motion to recuse, this was my argument to ask for recusal, right? That this judiciary system put me in a position of harm by sending me to mediation while the other party was calling me crazy, right? Because that exposes me to direct coercion with the threat of a psychiatric evaluation and a medical procedure and maybe even medication, right? Forced medication. So how can I negotiate anything in those conditions, right? I mean, it's like going to a boxing match with your hands tied behind your back, right? But they denied the motion to recuse. But when I made that argument, the argument is sound, right? But you can say, well, maybe the judge, he has so many cases, maybe there was no reason for him to believe that you were really crazy, right? But this is not the case, because this very same judge signed on 4/10 or 4/11 a temporary restraining order, potentially very aggressive, to the point that Morgan Heibner had the child secreted for 50 days, right? Fearing no consequences. So I imagine that the temporary restraining order probably stripped me from my parental rights in some way, right? In some measure. And this judge signed that, right? So he must know that supposedly I am that crazy, right? So how can he send this crazy person to mediation just 5 weeks after, right? So this is a tremendous contradiction. And now the pipeline, and this is where I say that it gets complicated, right? I don't want to make it confusing, but the pipeline, as you see, right, it thinks of legal arguments ahead, right? Like what's coming next, right? It thinks ahead. And it thinks, looking at the output, that this puts Morgan Heibner in a bind, right? In an existential paradox, because if she produces the temporary restraining order, right, then she would be admitting to, fraud, manipulating the record, obstruction of justice by not serving me the temporary restraining order and hiding it from me for months, right? And if she doesn't show it, then she is exposed to kidnapping charges, right? So it is, how do you say that in English? Heads I win, tail you lose, right? If she shows the order, and if she doesn't show it, it's the same, right? Of course, when I see the debug, right, like the liability, because I have metrics about I'm not going to give much about the technology, but I have metrics about how liability distributes to the network, right? The thing that exposes less the network is not showing the temporary restraining order, because then the only person really liable is Morgan Heibner, right? And then they could defend her, and they could try to mitigate that, right? But if she shows these mysterious document index 7s that she has, that nobody else has, then the liability distribution metric increases, right? But yeah, so the biggest anomaly is that it was the same judge that first signed that temporary restraining order that nobody knows what it says, right? And the same judge that felt compelled to sign that because of the evidence that he saw, right? There has to be evidence, right? It cannot be hearsay. It cannot be just the word of one party against the other, right? Like, as I said, right, I have pictures of the tires, and I was not able to secure a temporary restraining order for that, right? That was very narrow in scope, and I tried multiple venues. Let me tell you that. I filed that with the 387th court. They didn't do anything. I filed that with the first appellate court. They didn't do anything. And I filed that with the federal court in the case against Morgan Heibner, in the case for civil rights violation under the color of a state law. And it was denied, right? So I know from first-hand experience that is not an easy process to get a temporary restraining order against another person, even if the scope is super narrow. So I imagine that the amount of evidence that Morgan Heibner produced must have been a large amount, and also it must have been very powerful evidence, right? So the question needs to be asked: what was that evidence, and where is it? Like, I would like to see it. I would like to see what compelled a judge to sign that order, right? And I would like to see the order, right? I think I have that right. So I think I have the right to see the order and the evidence, right, that was used to secure that order. That's my humble request, right? If anybody watches this, that's what I would request. I would like to have the chance to see what was the evidence presented and what the order says, because at this point, 7 months later, I don't know what the order says. Well, thank you so much for your time, and I'll see you on the next one.